sort of, this is a two-part question. I want to get at the more general issue by asking, what does your approach say about the right to abortion?
I've been asking that question for years.
You might sort of, here's a sort of naive, simple take on it. Okay, the common law right was that a woman could abort prior to quickening. Lots of states passed laws that modified that, but those weren't general law. That was not part of the general law. The question is, what was the general law in the absence of those statutes, right? So you might think then that your view has it that the right to under the Privileges or Immunities Clause, a woman would have the right to abort at least up to quickening. Now, there's a number of possible ways you might modify that, or say, well, maybe it's not a general citizenship right, or whatever. But I'd be interested to hear what your answer is to that. Now, that then connects up to my sort of more general question, which is, wow, it's very interesting that statutes don't count in this area. And I think the abortion case is really is a striking example of that. And so I guess I'd want to know more about, what's the relationship between the statutes and the general law. You do say in the paper, well, maybe if statutes are operating in this area and there's no common law, we should understand the common law as the general law as having died. Perhaps, but I just would like you to sort of explain more, because I think it is I don't know if troubling is, but it's a interesting and worth exploring more, the fact that common statutes do not seem to get protected.
One other question that I thought this excellent paper raised was, does it revive, not questions about incorporation, but the idea of whether or not rights, federal rights, are enforced against the federal government as against the states, which is an old idea, generally defended on functional reasons, that we should have more stringent restrictions on the federal government with rights than with states, with exit possibilities. But doesn't your paper suggest that's a possibility under your view, but you really don't suggest it for this reason, that still, as against the federal government, this is enforced as a constitution, directly as a constitutional matter, particularly if you don't have, there's a right, the federal government doesn't have a power. But all you say is that you're just given jurisdiction, the federal government, to enforce the general law. And that general law may allow for states to define, maybe I'm going a little to the other 14th Amendment paper here, or to restrict or to qualify that right in a way that wouldn't be permitted, given the federal right is actually a provision of the Constitution, whereas this is a general rule, a general law rule with all of the possible qualifications that are permitted there.
Can you give me any example, another example of a consequential body of general law that is neither, that can be abrogated neither by the state legislature or the federal legislature, right? Because the Holmes taxicab case says there's no transcendental body of law outside of any particular state, but obligatory within it unless and until changed by statute. You want us to believe two things: that there is that obligatory law outside the state, and that they can't abrogate it, and that neither that Congress. So my first question is, if that's true and that's different, you guys are doing something that's much more shocking than you're letting on, right? You make it sound like forum shifting, jurisdictional, but really that sounds like a huge deal. So is there another example of a consequential body of law that operates like that? And then my second question is, you present the equality reading of the Privileges or Immunities Clause that I subscribe to and John Harrison subscribes to as puzzling. And so my second question is it really so puzzling? And let me point to two things. One is Article 4 was described as securing fundamental rights. And how does it secure fundamental rights? By requiring equality. Here's John King, his 1871 treatise, described Article 4 as securing the privileges and immunities of citizens of the United States, including the kinds of rights in the First 8 Amendments, by the way. How does it secure them? The states without Article 4, by their local legislation, might and perhaps would impose different restrictions on the residents of each other, militating against those unalienable rights. So here we have one precursor, Article 4. People thought it secured fundamental rights. How did it do so? By guaranteeing interstate equality. And then we have Lyman-Trumbull on the Civil Rights Act, which also a precursor, also guarantees equality, a different kind, right, based on the basis of race within a state. And Lyman-Trumbull says, in defending it, each state, so that it does not abridge the great fundamental rights belonging under the Constitution to all citizens, may grant or withhold such civil rights as it pleases. All that is required is that in this respect its laws shall be impartial. So the two key precursors to the Privileges or Immunities Clause, Article 4 and Civil Rights Act, each require equality, and each were described as securing fundamental rights. So is the equality view really so puzzling? Or in other words, hasn't John Harrison solved this problem for us already?
On abortion, there would be two questions. One, was there such a right as of 1868? And second, is there such a right today? On the first part, I'm not terribly worried about the sort of not necessarily criminal prior to quickening evidence, in part because I think Finnis and George have argued pretty persuasively that it may not have been criminal, but also was not lawful prior to quickening. They give various examples of how that would be. In addition, there are lots of common law rights to do stuff. There's a right to chew gum. How do we know that there's a right to chew gum? Well, if they tried to prosecute for you, you'd say this isn't illegal. So I have such a right. But no one would say that that is a right that would necessarily withstand a statute restricting that right. You may have that right at common law, but the 14th Amendment doesn't fix in amber all of your common law rights, only fixes in amber your rights of citizenship, and only with respect to abrogation. So even your right to contract can be regulated. They can say, well, you have to, if you want to sell land, you have to do that in writing. That would be totally okay. That's a regulation, not an abridgment. Was there a citizenship right to abortion as of 1868? I think the evidence is strongly no. And is there is there a citizenship right today? Could someone say, look, we've had half a century of Roe, we had, other statutory changes, this is seen as a right of citizenship among the sort of relevant population? One could try to make that argument. I would be skeptical of that argument on two grounds. One, because the abortion right has always been very heavily contested. It doesn't seem to have the same shape as these other general law rights. But also because I personally find quite plausible the sort of backward-looking reading of Corfield. There's a sort of protecting existing rights, meaning temporally existing, past rights. But people may disagree about that point. I don't think this paper certainly resolves it in either direction. On the first half of Alain's point, a body of law which is unwritten, which neither states nor the federal government can abridge, state borders. New Jersey cannot announce that it owns half of Pennsylvania, nor can Congress award half of Pennsylvania to New Jersey. The exact line between New Jersey and Pennsylvania is often a question of unwritten law, not of written. Now, I'm not saying that the 14th Amendment is like that. But the way that that's true is in part because Article 4 says you can only move the borders with consent of the states, and moreover, we are not prejudicing any state's claims. You're not touching this with a 10-foot pole. So in that way, it leaves the existing law of state borders in place and just says, don't touch it. Likewise, the 14th Amendment may in certain ways say, you've got all these privileges and immunities, states, don't touch them.
Can I say something about John's question? So this also relates to the point Jack was making in his nit. In order to figure out what the relationship between the privileges and immunities secured by the 14th Amendment and the Bill of Rights would be, you'd need to figure out what the Bill of Rights is doing also. And it's very possible that many of the aspects of the Bill of Rights that we would just conventionally, without thinking, treat as federal constitutional law are actually just picking up general law principles as well. And it's also possible that certain parts of the Bill of Rights are specifying in a way that would tied to general law, but adding a layer of determinate meaning that was not present in the general law. And you could easily see that as being a body of federal law akin to a form of regulation, but here it would just be a specification through federal law. And you just need to do the work of figuring out which provisions are doing the specification and which are just picking up the general law principles. That's not a task we can take up in this paper, and so we can't, then do the comparisons. But I think that's the sort of thing you would want to do in order to make an assessment of how the relationship works.
I'll go first very quickly. A statement and a question. No, legal realists did not kill the 14th Amendment. That's untrue. We'll talk about that some other time. My question is, does the general law have a procedural element? And procedural may not be exactly what I mean, but does it bring with it what judges ought to do when they are unclear? And I ask that because if I understand, and I may have this wrong in your paper, I apologize if I do, I think the general law predates judicial review. And if the general law predates judicial review, or is maybe even outside of that idea, then what do we tell judges when they're not sure when they're dealing with general law? That's my question. Julian.
I want to ask how I think about sort of an evidentiary question here for what you guys need to show to get to where you want. And I think the best way to explain the nature of the question is to try to just very briefly sketch like what's in the back of my mind as I read the paper. In the back of my mind as I read the paper, the evidence that you cite, the sort of the contemporaneous evidence you cite, sounds very much to me like comparable conversations in legal discourses that I'm far more familiar with. I just don't know 19th century cases very well. But boy, if I think about 18th and 17th century conversations around the nature of British constitutionalism, around the nature of natural law, around the nature of the rights of Englishmen, if I think about public international law discourse over centuries, including, by the way, references to general law, like I read the evidence that you're citing, and I feel like I don't literally do it, but for many of them, most of them, it felt to me like I didn't see one where I couldn't do this. I could plop in the word natural rights instead of general law, or plop in the word rights of Englishmen instead of general law, and it would make perfect and complete sense. So I think the argument is that there's something distinctive about saying this is general law versus the other sort of theories of the 14th Amendment. And I think that one of the major implications of that is your claim that this means that it's not federal. And so I want to ask, what do you mean by it's not federal? And what do you have to show to get there? I don't think you mean this. I don't think you mean it wasn't previously federal, and now it's federal because, right, like to say it's not federal means that it wasn't federal before. I don't think you mean that. I also don't think you mean it's not federal in the sense that you have to look for sources from outside the four corners of the Constitution and other, like, actual official government documents of the United States. That's true for lots of things in the federal Constitution. You just have to look for definitions elsewhere. Rather, I think you mean something like a forum selection clause, where we now have a new forum for adjudicating a particular kind of law, which is to say, a new kind of law, which is to say general law. And if I'm right about that, I wonder what you'd have to show to convince us that that was right. That what you're talking about here is not federal in a different sense from saying that the word seizure is not federal because look at all this other stuff you have to look at. Or letter of marque isn't federal because there's a body of law that it draws on. How do you sort of refute the naive hypothesis? This is working the same way as any other reference to a term of art, which takes a body of concepts that are super unclear and contested and overlapping and like super poorly thought through, and then you kind of argue about it from there.
We'd like you to elaborate on how you understand general law in relation to bodies of law that are more familiar to us, or terms that are more familiar to us, namely natural law, common law, customary law. You're clearly talking about some body of unwritten law that's trans-jurisdictional. If we're thinking about recovering a lost way of thinking about the law, and we're looking back to the 19th century, I'm not familiar with that many people at that time who used this nomenclature, who used the term general law. I think in certain special circumstances like general commercial law or something like that. But generally, if you read the literature of the period, and certainly the 18th century literature as well, people are talking a lot about natural law, they're talking a lot about common law, maybe customary law. When it comes to rights, they're not using terms like general law rights, which is your invention. They're talking about natural rights. With respect to the 14th Amendment, I think of work by people like Howard J. Graham and Jacobus Tenbrook, talking about the abolitionist origins of the 14th Amendment and the idea that maybe the 14th Amendment was declaratory of conceptions of natural rights that were really animating abolitionism in the 1830s, 40s, and 50s. And those people, again, I don't think they were using this term, general law, very much. They were using other terms that are comparable to the concept, clearly that you're talking about. So I'm a little bit puzzled if the project is partly to recover older ways of thinking while you're introducing this new term. I couldn't help but think, as I was reading your paper, which was very persuasive on many points, but of something that Ronald Dworkin once said, I think around early 80s. He said, law professors, they love labels, they hurl them at one another, they take them on and they use them quite a bit, but there's one label that no one wants. No one wants to be called a natural lawyer. This was Dworkin in 1982. I'm kind of the same mind as Jack Balkin. This didn't read to me at all like a positivist paper. This read to me like a natural lawyer's paper in some respects. I know you have thought a lot about the relationship between positivism and natural law, but I just would like to hear more from you about how general law relates to, maybe is different from in some respects, things like the common law, natural law, and customary law. Last point I'll just make, you bring in Holmes repeatedly. He was talking about common law in many of the instances that you're mentioning. He doesn't use this term, and I wonder what is going on, with this new term that might be different from the older terminology.
I'll take Julian's question here, which I really like and want to fight the premise of to some extent, which is to say our instinct is to read all these provisions that refer to a common law term of art as elevating that term of art into federal law. But that may be wrong. That is, it may be that the First Amendment reference to freedom of speech is itself just an invocation and restatement of a general law concept. And so the type of approach we're taking might be inconsistent with all sorts of other aspects of the Constitution. That itself might just be a feature of the way we view those other aspects as opposed to something inherent to those. I mean, oh, I see. I mean, I think it's hard with respect to other parts of the Constitution because that's not what the debate was about. But there certainly are people at the founding who are making the claim that the rights we're recognizing are the rights of Englishmen. In relation to John's question, I treat the rights of Englishmen not as a synonym for the concept of general law, but as a subset of general law. And so when people are invoking a type of transjurisdictional law, be it rights of Englishmen or retained natural rights or common law, what they're invoking is a type of general law.
I guess this relates to both Julian's and John's question. I think, you said the general law and more familiar terms like natural law and natural rights. In the circles I travel, the general law is the term I'm most familiar with, and then these other words like natural law are the ones that confuse me. So I think the general law is the label in modern scholarship about federal courts and federal jurisdiction for the sort of general problem of transjurisdictional law, which ranges from the law merchant to customary international law to the law of international borders. And it's especially helpful now because there are so many different labels, and people could refer to the common law of America in a way that they would mean what we would now call the general law, because they didn't have the concept of the federal common law or the national common law. But once we now have the modern concept of the federal common law, we need to be careful about preserving sort of a label that distinguishes it from things that now exist that might be confusing from it. So the general law label is there partly to help modern lawyers understand the category of things we're talking about, but in a way that a fish might not need a word for water. We might still need to write a paper about fish that talks about water a lot.
So I think two quick points. One on Eric's question. I think people argue about what to do when the law is unclear, and they argue about it within sort of general law frameworks and within other frameworks too. I don't think we have any general solution. And I'm sure the three of us would have at least 3, maybe 4 answers. The other point that I wanted to make on John's question, sort of where is the positivism in this? So it depends how one understands positivism. If you're if you think positivism means the way Holmes did, like every law comes from some definite authority. There was some sovereign who said, "Thou shalt," and laid it down. Well, no, we're not saying that. We're not saying that it's hidden in text somewhere. We're not saying that the judges who announced common law decisions in a trans-jurisdictional way were making those rules as they announced them. But you can have standards and norms that come from social practice, like customary law. They're not natural, they're conventional. And they're positivist in that sense, in the sense that they are not purely derived from ethical reasoning. And that would be a form of positive law that is not written necessarily, but still has its roots in social practice. And that's the sense in which we think, at least I think of myself as a positivist, and in which I would see this paper as following in that tradition. The reason why these things are the law is because they at the time recognized it, not that they had to do it, and that if they failed to recognize all these natural rights, they were just wrong about what their law was.
So suggestion 1, in answer to the questions just raised, one suggestion for research, look at section 2 of Blackstone's commentaries, volume 1, the introduction. And he talks about the relationship between law and rights and statutes. And so some statutes are declaratory of rights. And I'm sure there are going to be cases that are picking up on the idea that some statutes declare rights. And that, I think, provides a lot of the answer to the 2 questions you just had. On the same train, I agree with the paper a lot. I think it would be stronger if you used Blackstone, Kent, and Cooley, more treatises. And like if you're talking about the general law, these treatises, I think, caught the tenor of the general law more. And for example, Blackstone talking about privileges and immunities of English citizens. And I'll send you thoughts on that. The question is this, reacting to the paper, the title is about the general law and the 14th Amendment, but it's very much general law and mostly the privileges or immunities clause and a little bit of the rest of the paper. And so the question for you all is how might we read the equal protection and due process clauses differently, since they focus on people, not citizens? And maybe the most pointed instantiation of the question, is substantive due process required by or authorized by the general law, or is the due process clause a lot narrower?
I had a very similar question to John McKyle, so I'll just sort of echo it. If we're sort of thinking of the terms that were often used at the time, the subtle differences between fundamental common law, ordinary common law that picked out the rights of Englishmen, that was declaratory of natural law, or in other cases wasn't. Do the subtle differences between these matter, which I think is a version of what John was asking about, so I'll echo that. And then related to that, the portrayal of the shape of the concept of general law struck me as pretty static, as though it was more or less the same from the founding to the 1850s. I'm wondering if there weren't important changes in not just the details, but the shape between that period, and then does that matter at all? I sometimes felt like I was reading something that was about how people in the 1850s had come to distill it, and that might be all you need. But it seemed to me that you could argue if you went back to 1795 or 1810, you'd find differences not just in the details, but the shape, and I wasn't sure if that mattered.
Footnote, I don't think there's any problem reconciling this approach with positivism. There's inclusive positivism, which allows moral considerations in, and there's no reason why natural rights, other rights couldn't come in the same way and be consistent with positivism. But that's not my question, and you've alluded to it, but I was, if courts are to enforce under the privileges or immunities clause the general law, is it the general law that is preserved in amber in 1868, or has the general law changed since 1868, and what is the relation of that to the Privileges or Immunities Clause? I also have a question about equality here. So if these rights can be regulated, if not abridged, but regulated, and a state regulates a right, but it preserves the right, but discriminates in the sense that it leaves other people unregulated, it gives them a greater right in that sense, unregulated or less regulated. I take it that that public purpose has to come in here somewhere, and where do we find the sort of Rosetta Stone for decipher what the public purposes are? For example, in Plessy versus Ferguson, the court cites a purpose, right, of the comfort of the citizenry. Would that mean that there was no abridgment of privileges or immunities there? And then I think the question was just raised, but I had it on my list of how do you deal with discrimination against aliens if the Equal Protection Clause is about protection and the Due Process Clause is about process, and privileges or immunities are conferred on citizens? Where do discrimination against aliens come in?
My own view, I can't speak for my co-authors here, but my own view is that the Privileges or Immunities Clause covers rights that include equal protection and due process. Those two rights also extend to persons. This is a view Jack has taken as well. And so that helps us address, at least to some extent, why the discussion doesn't focus so much on delineating the clear boundaries between these different concepts, because at least as relate to citizens, they're sort of all recognizing a common bucket of rights. So there's a lot of fluidity in the debates between equal protection, due process, and privileges or immunities, and I think that makes a lot more sense when you recognize that, for instance, the protection of law is a right of citizenship. That doesn't quite get to your question, Larry, but I think it is a kind of useful framing device. In my view, the idea of substantive due process at this point is so far below a consensus position. I mean, there is an idea in some of the cases in the 1850s, but it's a distinct minority idea. The way that you would get to something that's like that might limit the government's power to regulate with respect to aliens would be just the idea that there are limits on what the governments are constituted to do in the first place, that those limits then can somehow get picked up through a claim about the deprivation of liberty pursuant to a law that is not actually what purports to be a law that's not actually a law. So it's not that the Due Process Clause is providing any substantive content whatsoever. Rather, it's just the conduit for bringing a claim about the invalidity of a prosecution pursuant to a statute that is not actually law. And that's the posture of the early cases. Randy has written up something that's very much like this. So, thanks.
So I think 2 points that I want to make, and I don't know if we'll all sort of get to every point in the various questions as we divide it up. The other thing I want to know for discrimination vis-a-vis aliens is, for me, I'd want to know a lot more than I do about treaties of amity and commerce, about the rights of alien friends, about what an amity treaty conferred. Certainly, I think that there's widespread evidence that rules that non-citizens could not own property were very widespread in the founding through the 14th Amendment and after, real property, I mean. And in many states, well into the 20th century, the certain things might have been not guaranteed by due process or equal protection and solely have been citizenship rights, and those, so long as no treaty prevents them, the states could very well infringe. might not have been able to infringe it vis-a-vis one class of non-citizens as opposed to another. So the current question about whether Texas can restrict, only a few people's from a few countries' right to own real property, I think is a separate question. I just don't know yet. I need to drill down further there in commerce questions and other kinds of questions as well. The other thing I wanted to note about the question about did the shape of general law remain the same from the founding to the 1850s? I'm not 100% sure. A lot of the sources seem to think that it had, but that just might be that they were writing in the 1850s, and so they thought, oh, yeah, of course, we've always been using the same concept, and maybe they hadn't been. I think you're probably right that it would be okay by us if they had, I don't think it would sort of undermine the paper if it had in fact changed. What it might matter for in part is the question of how do the rights protected under the 14th Amendment hook up to the First through Eighth Amendment rights, especially if those were in part general law rights. And I believe Judd is writing on this right now, and so there's lots of theories that might go into that, but that would be sort of the questions it would raise.
So I was going to say, Jonathan, your question is the one that has literally kept me up at night as we were working on this paper. So in the 20th century scholarship, there are a lot of people who think Justice Story's opinion in Swift versus Tyson is not consistent with the general law at the founding, that this was like a, law merchant nationalist Justice Story project. That wouldn't shock me about Justice Story. So far I'm not convinced it's true, but it wouldn't shock me. And Justice Holmes believed that even if Swift versus Tyson might have been okay, the things got really dicey in the 1860s when the Supreme Court started intervening in a bunch of municipal bond cases, most infamously Gelbke versus the city of Dubuque. And that general law was like what he was really against, even if maybe he was okay with some version of Stories. So none of this is in the paper because it's already too long. But anyway, so far I'm not actually convinced that these critiques pan out. And I think Steve's right that if they did, they'd have to change some of the things we say, not the fundamental claim. But I will say this is the thing I lay awake at night worrying about.
I don't think you have fully addressed John McKyle's question. And in particular, I want to know exactly what the conceptual relationship between general law and general common law is. And one way to sort of get at that is to think about footnote 64 in Louisiana, right? So there's no general common law in Louisiana, and a lot of writing at the time uses the phrase general law. There's no general law in Louisiana. You try to wiggle out of that in the footnote, but you don't take into account the rise of the field codes, which starts in 1840. So by 1868, everyone was familiar with the idea that the common law could be replaced with codification. And so, and by black and white taxi cabs, as Will just indicated, a perception was arising that states could have their own common law on topics that were formerly general common law topics. So I'm really wondering whether the concept of general law and or general common law necessary for the paper's interpretation of the Privileges or Immunities Clause was actually intact as of 1868, and what the implications would be even if it were intact as of 1868, if by the late 19th century it had dissolved. And obviously it had dissolved later, and it is dissolved now. And of course the paper brackets those questions, and I just think that those questions are so very important that maybe just saying, well, we don't know, is not fully satisfactory.
Oysters, schools, and voting. If you look at the 1872 evidence, the way Matthew Hale Carpenter looked at it, he would not say voting is like oysters. He would say voting is a political right, it's not a civil right. Seems to me you could have oysters. So, suppose a state said only white people can harvest oysters. I think that's a big privileges or immunities clause problem, even if it's excluded from privileges and immunities, because locality matters. Locality might matter for Article 4, but not for the 14th Amendment. And schooling, you gotta explain whether schooling is too local, because in 1872, and Carpenter's theory, I think, is better than yours. If you look at, for the word general in all the 1872 stuff that in my absurdly long appendix of my book, the only person who uses it is Alan Thurman, and you do not want to be with Alan Thurman, because he is just the least trustworthy of the whole lot of them in the February 6th, 1872. Anyway, much more to say.
So, a few things on that. One, again, on the word general, I think, we're using it because that is, in the fields of Fed courts and to some extent CivPro, sort of the label we now give to a swirl of other expressions that were used back in the day. So I'm not too worried about that. What we're looking for are sort of rules that are of this unwritten trans-jurisdictional Anglo-American law. And with this, to Larry's point, I'm not particularly worried about Louisiana for a couple of reasons. One, because Louisiana wasn't one of the original 13 states. If it were, that would keep me up at night. It doesn't because, you look at sort of discussions by Marshall about sort of the substratum of American law. You think about something like the Seventh Amendment, though its interpretation is obviously contested, but it's certainly assuming that there are rules of the common law that would apply, that the judges in every state can figure out. And the idea of a law that is general, that is unwritten, would include general common law, it would include equity, it would include admiralty, it would include customary international law, it would include all these sorts of things. It could certainly be abrogated by particular states within their legislative competence. So you can have, Louisiana can adopt contrary law, that's fine. States can adopt common law of their own. They can have customs and usages, as Story described, that would in some real sense be the common law of New York, both whatever aspects of the general law it adopts and also the unwritten law of New York itself. So I'm not too worried that those super additions to the general law sort of wiped it out underneath. It's still there if the super additions were to be removed. The question I think that's harder is sort of the 20th century question. What do we make of this change? So if it were the case that, Erie had said, oh, we used to have a lot of consensus on these points, now the consensus has broken down, that might be slightly different from what it did say, which is they were just jurisprudentially mistaken. They thought this kind of law could exist, and they were wrong about that. And I think Erie was wrong about that. In fact, that kind of law can exist. There's nothing wrong with it. And so I'm not sure that it's possible for Erie to do what Guaranty Trust said it did, which is to overrule an entire way of looking at law. I just don't think the Supreme Court has that power. Now, it may be right now that there are sort of no agreement on the sorts of things that general law requires agreement on. I agree that that's a big question, but I think that, the originalist part of our paper is to try and figure out, okay, what rule did the 14th Amendment lay down? And then there's maybe, several more papers to figure out where does that leave us right now? The one thing I will say very quickly, because time is pressing, is that at least in the field I know, better in my own work, like on personal jurisdiction, which I also argue is an area covered by general law, since International Shoe, we haven't really been sort of toiling in the fields of general law. We've been doing something else. And so to the extent that there were rules that were the rules of general law, the ones that you might say at common law, comma, ... as to, those may very well still be there to the extent that International Shoe goes away. And the same thing might be the case here, that if we removed all of the Supreme Court super additions, wherever the general law wound up is where we would be left. Thank you.